Morris, if able. Appeal in the matter of infrastructure services, Luxembourg, Sarl and another, and the Kingdom of Spain.
Yes.
Morning, my lords. Just quickly, in terms of timetabling, my learned friend and I have spoken, and he will endeavour to finish by 2:30 tomorrow, and I will then take up about 15 minutes in reply. So we should be done by 2:45 in order for the next appeal to start.
Okay.
At around 2:45 tomorrow, if that's
Well, that
good with you,
sounds.
my lords.
That at least gives me. Yes.
If I can go any faster, I will.
That depends, I suppose, on when Mr. Ballock sits down.
I have full confidence, by the way.
So, and the questions one may get, but this is very important on my
We'll try and
time.
keep quiet.
No, I didn't mean to say that. The questions are a good thing. We want to test the case, but this is very important, as you can imagine, not just for Spain, but all European states.
Understand. Well, it's also very important that, if we do have questions,
Absolutely, my lord.
that we ask them.
Yes.
Because otherwise you end up in a situation where you wish you'd ask the question because you can't work out what the answer is.
No, absolutely, my lord. And I would, if I would not suggesting that, we want questions. We want to test this.
No. Okay.
My lords, with that out of the way, and if you're still okay with us dispensing
sounds
with
fine.
gowns and the wig, can I just quickly summarise where I got to yesterday? And that's this, that there is a conflict, at least the judge found, his lordship found, between, as expressed by the CJEU, between the EU treaties and Article 26 of the ECT.
Yeah.
The question is, does that have an effect in international law? I submitted to you yesterday that by way of the international rules of treaty conflict, that is how it will be resolved. And I haven't got to that conclusion yet. All I showed you yesterday was that the rules of treaty conflict are not just to be found in the VCLT, they can be found in other sources, in the treaty itself, or in the parties' practice.
Mm-hmm.
And what I was going to show you was that that's exactly the situation in the EU context. Lord Justice Phillips asked me, are you actually going to show me Article 26? I will show it to you right now, my lord. And where I end up with this analysis is that as a matter of the rule, by operation of the rules of treaty conflict, and the treaty conflict rule here is EU primacy, that particular provision allowing for arbitration in the ECT is disapplied. That word is important, my lords, because we are not asking you to interpret 26 to say that it doesn't apply in this case. It is disapplied. We accept that on its terms, and we can go to it now, it allows for arbitration. It's a standing offer for arbitration. But by the operation and application of the treaty conflict rules, it is disapplied ex tunc, i.e. from 2000.
But if you're right, the treaty conflict rules trump it. And if you're wrong, they don't.
Yes.
And so I mean, the question we've got to decide is really whether you're right about the EU law.
Exactly, my lord. And really the three questions I put to you were designed to address what I would submit are the issues that you may have in your mind. The first is there such a rule that applies in the context on the international law plane? Secondly, when does it apply from? Because the conflict that was announced was after the arbitration started. So is it retroactive? And three, is there a difference? Because we're in a multilateral contract context. So this is not just a conflict resolving two bilateral treaty situation. It's a situation where we are disapplying Article 26 in the context of a multilateral treaty, but only in the intra-EU context between the EU parties. So I need to show you that that is also possible. And that is what the three questions I put to you yesterday, my lords.
So hang on a moment, just on the second question.
Yes.
Did I hear you correctly that this conflict which you rely upon arose after the arbitration had commenced?
Yes, my lord.
So the arbitration is on foot.
It was identified after, my lord. It was identified after. I'm going to take you through it.
After the arbitration had taken place, the whole thing?
Yes, my lord. I'm going to take you through the chronology right now.
With no reservation by your client during the arbitration as to jurisdiction.
My lord, they did make.
Well, I know but they didn't make this reservation.
They did say that these articles conflicted, but those cases that announced that they had not been issued at the time. I'm going to take you through the chronology, my lord, and we'll see
Okay.
that. Yeah.
Right.
But as I said to you, where I got to in my analysis was to at least establish, I hope, or to show you that treaty conflict rules are not just in the VCLT. They can be in the treaty or in the practice. And what I wanted to, just before I get to the specific way in which those rules are expressed within the EU legal order, is to just show you why the CJEU has a very special role to play when it comes to treaty interpretation. As I put it, it acts more like a mouthpiece of all the states. It is speaking as if all the states are saying to you, this is how the treaty should be interpreted. So for that purpose, can I just take you to Article 19.1 of the TEU treaty, which is in A7, Bundle 7, tab 109.
I'm really sorry, could you give me the reference again?
Sure, of course, my lord. It's Bundle 7, tab 109. And it's page 3692. My lords, this provision expressly directs the CJEU will interpret the EU constituent treaties. And it's in 19.1, you'll see the Court of Justice, it shall, sorry. My lord, it's at 3692, bundle page 3692.
Yeah.
And I'm looking at Article 19. Article 19.1 says the Court of Justice of the European Union shall include the Court of Justice, and in the second sentence, it shall ensure that in the interpretation and application of the treaties, the law is observed. So we see immediately from this that the CJEU is a custodian of the interpretation and application of the EU treaties, which includes the TFEU. And then in Article 19.3, my lords, you'll see the Court of Justice of the European Union shall, in accordance with the treaties, rule on actions brought by a member state, an institutional or natural legal persons, give preliminary rulings. And as I said yesterday, preliminary doesn't mean provisional. It just means when the court, domestic court or municipal court from the European Union refers questions, that answer goes on its way as preliminary to the final decision. At the request of the courts or tribunals on the interpretation of union law, the validity of the acts adopted by the institutions. My lord, and it's well established that the CJEU is given the power by the TEU to interpret the treaties in the course, as I said, of giving a preliminary reference. And the basis for that is also Article 2267, which I took you to yesterday. And my lord, this is why international law texts on treaty interpretation expressly mention, and I'll show you, the CJEU practice as a source not just for the interpretation of the EU treaties, but also other treaties concluded by the EU member states that may conflict with their obligations under the EU treaties.
That's not, we don't derive that point from this article.
No, my lord.
Because the treaties that are referred to here are this treaty
Yes.
and the TFEU.
My lord, but it also says it's the guardian of EU law, and you're absolutely right, my lord. When I take you to the cases, and that's where this rule resides, it's in the cases of the CJEU that you see that priority that's given to the EU treaties over any conflicting treaties concluded by the EU member states.
Sorry, I repeat the question. Is there anything in either this treaty or the TFEU which says that these treaties, these two treaties, take precedence or primacy over any other treaty that's entered into by a member state?
No, my lord, that's in the CJEU practice.
So that's all from the court?
That's all from the court. There is a conflict rule here in relation to member state treaties signed with third states prior to accession, and I'm going to take you to that, my lord. I assure you all these questions will be addressed. I'm trying to build it up slowly because this is not straightforward. My lord, now coming back to the treaty conflict rules, the only, and this is what I was going to take you to now, the only conflict rule expressed in the EU treaties is to be found in Article 351 of the TFEU. And I'd like to show it to you. It's in the same bundle in tab 110. at page 3719. And this is not the rule applicable here, but it's an example of a rule of conflict. And the rules, the treaty conflict rules are both in the treaty and outside it. And this rule, as I said, when you read it, is about the first part of 351. I'll let you read it. My lord, the first part of 351 explains that pre-accession treaties with third states are not impacted by the EU treaties. This is a well-known conflicts rule that was actually at the center of, well, one of the key issues in the Mika case in the Supreme Court. And I'm going to take you to that.
What was the date of accession of Spain to the EU?
Okay, I should know that. 86, sorry, 1986, my lord.
1986.
Yeah. I'm not relying on this rule for disapplication. I'm just trying to show you that there are rules both in the treaty and outside. And my lord, if I can just take you to Mika, where this rule was key, and then you'll see where when the Supreme...
This rule, this article, wouldn't of itself lead to disapplication of the ECT, would it?
No,
if
no,
the
my lord.
ECT is prior to, I can't remember when the ECT was entered into. It's later.
Later. My lord,
Later, is it?
my lord, just to be clear, I'm not saying that this is a rule that applies. I'm just trying to show you, just in terms of framework, that there are rules within the treaty and outside. And I'm going to contrast.
The ICSID treaty was entered into before.
Yes, my lord.
Not by Spain.
What's that?
It's not by Spain.
No, but can you, my lord, can I just show you in Mika, and then I'll explain all these things to you in terms of chronology. My lord, can I just take you to bundle 4, tab 45?
For my part, I really understand that you want to build the bricks,
Right.
but it'd be really helpful to understand, for my part, the overall where the bricks are leading to. And I'm finding at the moment working out where this is all going quite difficult.
That's why I keep asking the question, because you show us things and they're not, and then you say to us, well, it isn't actually applicable or it isn't relevant. So anyway, you want.
My lord, I just want.
Mika.
If I take you to the Mika case right now, you'll see where I'm headed, if I may.
All right.
Because, my lord, as I said at the beginning, what I'm going to show you is that there are conflicts rules in the treaty, which is this one,
Yes.
and there are conflicts rules in the practice of the CJEU, which is the EU primacy rule. And that EU primacy rule says that any treaty concluded by the EU member states which conflicts with the EU treaties is disapplied.
Yes.
And as I showed you, the CJEU has decided that that rule applies to disapply Article 26. And the battleground is to show you that that rule, the conflicts rule that the CJEU is applying, is an international law rule.
Because
Because, my lord, it's a treaty conflict rule, and in terms of how treaties are interpreted, they can only be the law of international law that applies to that. But if you're not with me on that, when I take you through,
where does that then take us?
that takes you this way, my lord. The ECT is governed by international law. You,
And how do I know that?
in Article 26(6) of the ECT, says
At
so.
some point you're going to take us to see that, because that seems to me, until we see that and look at it, none of this makes any sense to me.
Okay, my lord, I'll show it to you now.
And also, I'm right, aren't I? That, I mean, Mika is the case which has caused the battle royal between this jurisdiction and the Commission and the EU, because the EU, the court has said that Mika is doesn't comply with EU law, but this court is bound by a decision of the Supreme Court.
My lord, nothing I say to you today is telling you that what the Supreme Court decided in Mika is wrong, because they were deciding a different sort of conflict. I'm asking you to resolve a different conflict about treaties that come after.
It might give us a clue as to whether or not EU law trumps. Anyway, we keep, two of us are asking potentially conflicting questions, or I think we're generally facing in the same direction. Do you want us to look at Mika first, or do you want to show us Article 26?
Can I suggest this? Can I show you what I was going to show you in Mika and then take you immediately to Article 26?
All right, let's do that then.
So Mika, my lord, is in
Tab 45.
yeah. It's in Bundle 4, Tab 45. And it's paragraph 97, my lord.
Let's read that to ourselves. Yeah. Yep.
My lord, what I wanted to show you, and perhaps I should be censured for, I'm trying to be complete just for your analysis' sake, that we are not in the realms of the rule in the treaty. There is another rule, and it's mentioned here in the paragraph, which is, you'll see, towards the end of it, moreover, Article 351 of the TFU does not apply to the obligations of a member state under a pre-accession agreement where the rights of non-member states are not involved. If the only obligations in play are those owed to other member states, and the matter is regarded as an intra-EU matter, and EU law prevails over obligations under pre-accession agreements. Now, that's talking about that rule in the pre-accession context from the CJEU, and it's a rule that's outside the treaty, and I'm going to show you that there are cases that show it's quite consistent, and the books confirm it, that also applies to agreements concluded after accession.
Because, I mean, on its face, this is just really construing Article 351. It doesn't seem to go any further.
Well, my lord, it's like what you see in the brackets. It's referring to cases which have established the rule of EU primacy that applies outside 351. It's a different rule.
I mean, those are just European cases, aren't they?
They are European cases. So, as I said to you, the burden on me is to show that those cases and what they say about the rule of EU primacy is international law. But I just wanted to show you that that is established in the cases. And can I then just show you Article 26? Right. That is in tab 106 of A7.
Sorry, again, I was behind.
Sorry, it's tabs. It's the same bundle, my lord.
Yes.
It's tab 106. Bundle 7.
Yes, thank you.
My lord, and it's page 3618. My lord, what we say, and what the CJEU has said, and where I will end up with this analysis, is that Article 26.3a is disapplied as a matter of international law, which is the law governing this agreement and this arbitration agreement.
Article 26, what, 2A?
3. Yeah, 2 because, yes, it refers to the disputes. Sorry, Article 6.2, and then 3 is the arbitration, which is the basis from which the arbitration.
Well, let us read it.
Yes, absolutely. Well, and the other one to read is 26.6, which talks about international law.
Yep.
So where my analysis is headed, my lords, is that the treaty conflict rule established by the CJEU has international law effect. And if that's correct, then this provision allowing for arbitration is disapplied.
So what this provides is that it shall decide the issues in dispute in accordance with the treaty and applicable rules of international law. That's, as it were, that's the law of the dispute.
Right, my lord.
Why does that then apply to the question about whether or not the article governs?
Because, my lord, we're talking about the interpretation of treaties, and there is only one law that would apply to that, and that's international law.
Do you suggest that 26.6 adds anything?
Well, only if you ask the question, is international law, as I was asked, I say no, because it's an international, the treaty has to be interpreted under international law. And international law, what are the rules of conflict and what's their effect? So I don't think it does.
I mean, it doesn't in any sense, I follow your general point, of itself it doesn't seem to add anything, because it's saying, well, when you've got a tribunal, it's supposed to apply international law, but you say, well, you can't have a tribunal at all as a matter of international law.
Yes, my lord, yes. If the disapplication applies, because
I
you wouldn't
noticed
have an
that
arbitration.
at the outset, there was a list of the countries that are parties to this treaty, which includes the European Union, which granted approval on the 16th of December 1997, which coincidentally happens to be the date when most of the rest of the European Union, including ourselves, ratified the treaty.
My lord, if your question is why didn't they put in some sort of reservation or a disconnection?
I'm not saying that. I'm just trying to understand how a provision of this treaty can be disapplied if the European Union itself has approved the treaty.
Because, my lord, conflicts and conflicting treaties can happen as...
Well, you say
my lord,
that, but I mean, well, you're going to have to show us an authority that is directly applicable. It may be one of those two EU cases, because you haven't shown us.
Yes,
those
I'm
yet,
about to take you to them.
that show that notwithstanding that the European Union has approved the Energy Charter Treaty, its provisions are for some reason disapplied, and this court should recognise that the provision should be disapplied. Because I personally find that absolutely staggering.
My lord,
Quite blunt with you.
My lord, I understand that, and that is why I was trying to do it brick by brick, and I apologise for that. But
Okay, so
I will be deserving of all censure if you don't at least understand my argument at the end.
We've got Article 26. We've seen that.
You've got Article 26. If I can just take you through the case, I will end with sorry.
Can I just understand what we're trying to deal with here? This is a treaty to which the United Kingdom is party.
Yeah.
And on the face of it, it provides that there may be arbitration, including under ICSID, which I think is the effect of 4.
Yes, my lord.
Subsection 4. Now, isn't the application of that treaty by these courts, to which the United Kingdom is party, a matter of English law?
No, my lord, because my lord, what the English court must do, I submit, is to apply the governing law of the instrument. And the governing law of the instrument says, I submit, that in relation to an EU investor suing an EU state, this arbitration agreement is disapplied. It's not English law that applies to that, my lord. I wouldn't even know what the English law would be in terms of interpreting a treaty.
We can see that the United Kingdom is a party to the treaty. So is the EU. We are not party to any other treaty which might conflict. So why when we look at section 9 and we see that there is a valid arbitration under the terms of this treaty, why are we concerned with any potential conflict with any other treaty to which we are not party?
My lord, because as a court, the steps you laid out include analysing the validity, as you put it, of the arbitration agreement under its governing law. And under its governing law, if I am correct, that arbitration agreement has been disapplied and it doesn't apply in this dispute.
You referred a moment ago to the governing law of the instrument, which seemed to me to be potentially a bit confusing. Which instrument contains the governing law for the purposes of this treaty?
My lord, it's an international treaty. It's a treaty, and a treaty is governed by international law. And if you
What's the governing law?
my lord, it's in 26.6 as well, if you have any doubt. My lord, there is no other law that applies to the interpretation of treaties. When you're interpreting a treaty in this court, you will always apply international law in terms of interpreting it.
But 26.6 is, as my lord pointed out to you a moment ago, is not about the, as it were, a prior question as to the application or otherwise of the treaty itself. It's about a dispute under the treaty. So it's entirely predicated upon there being a valid dispute or a valid dispute with a valid reference to arbitration under the treaty. And then what it's telling you is what system of law you apply to determine that dispute in arbitration.
My lord, but if these cases, after these cases have determined the conflict, these arguments that I'm making in front of you, based on international law, would also be presented and could also be presented to the tribunal. So it's not that I'm...
Could be presented.
They could be, and they are, in multiple tribunals. So I'm not suggesting that only you can look at this, but the question is, and that's...
Well, if the arguments could have been presented and...
Not in this tribunal, my lord, because the case came after, as I will show you, but and the whole
No, but
point...
they could have been presented.
My lord, the case my client tried when the case was issued, Acmea and Comstroy, but it was not allowed, submissions were not allowed because I think it was too late, or I don't know why the tribunal decided as it
How
did.
can we go behind the tribunal's decision on that? That's Mika, though, isn't it?
Well, no, my lord, it's section 9. Our submission to you on the state side is that under section 9, you are not bound by what the tribunal said. So even if the tribunal had decided this issue, you are permitted, we say, under section 9, to rehear the matter. That's what section 9 requires you to do.
Well, that's what you say it requires.
Yes.
And just getting the larger picture for a moment.
Yeah.
Under Article 54 of ICSID,
Yeah.
each contracting state is to recognise an award rendered pursuant to the convention. Here, as I understand it, the punchline of your argument is that there is no award rendered pursuant to the convention.
Yes, there is no arbitration agreement.
And therefore no
Yeah.
valid award.
Because the ICSID Convention, in its very preambles, on the 7th paragraph, I think, presumes and assumes that there is a valid arbitration agreement pursuant to which there's been an arbitration. So it's a plug-in to an ECT or a bilateral investment treaty or a commercial arbitration. My lord, I appreciate this sounds as Chancellor says sanguine. So if I can just carry on developing it.
Like my lord, I'm simply trying to understand what it is that you're arguing. At the moment, I'm still a bit puzzled.
It's helpful to and the starting point is section 9.
Yes.
And I think I now understand that what you're saying is that in section 9, you are saying there's no valid arbitration agreement because although we are bound by ECT Convention and ICSID, the 1966 Act, nevertheless we are entitled to say, based on international law, which you say governs the treaty, that because of the conflict which arises, there is no valid arbitration.
My lord, when you say nevertheless, if I may, being a bit picky on the question, on the wording, nevertheless suggested that the conclusion I'm asking you to reach, on our view, is somehow inconsistent with the ICSID. It's not. because ICSID, as I said, proceeds on the basis that there is a valid arbitration agreement. That's number one. And number two, my lord.
ICSID proceeds on the basis that its arbitration decisions are binding or be enforced.
Well, but my lord, there has to be an arbitration agreement for that to happen. ICSID doesn't dictate any question.
But you're saying there's a conflict.
The conflict is with the ECT, my lord, not with ICSID. And the fact that the UK is a signatory to ECT does not in any way conflict with what I'm asking to. In fact, it complies with it because the UK has an obligation to comply with international law and interpreting the treaty. And if you come to the view, as I submit to you, that the treaty conflicts rule have international law effect, and they do result in disapplying Article 26, the UK will not be breaching the ECT.
So the sort of broad theory is a larger group sign up to the ECT.
Yes.
But as it happens, subsequently, some of that group are bound by the TFEU with the consequence that as between themselves, we have to proceed on the basis that the arbitration provision doesn't bite.
My lord, and that sort of arrangement, what they call an inter se agreement, is not unusual in international law. I took you to Article 30, not just to show you that conflict rules exist, but they also envisage inter se, well, the VCLT also envisages inter se agreements, but that's exactly it, my lord. And what I was going to tell you, but you, and please tell me if I'm going too slowly, what I was going to show you were just some examples, the one main example, which is mentioned in Mika, of the case that established EU primacy. We then have collected, and I'm also conscious of the time, otherwise I would have spent more time on Section 9, my lord, but Zimbabwe will be doing that. But to show you that the EU primacy rule is well established.
Thing is, I suspect we're very familiar with that rule.
Okay.
I mean, we were until recently members of the EU, and we operated on that basis all the time. The question is whether that rule bites in relation to
As a matter of international law.
us as an outsider now.
Yes. You're quite right, my lord. So if that is correct, can I then just give you the references and then move on to leading international law text, which recognises the EU law, treats the EU law of primacy as an international law rule. If you're not with me on that, my alternative is that Article 5 of the, I'm just previewing the arguments, Article 5 of the VCLT, which is unfortunately a little known provision, but that says that the rules of an international organisation are to be treated like international rules, and they take priority over the other VCLT rules. So even if you think that is just an EU law rule, that is treated by international law because it's a rule of the international organisation as an international law rule as well. So can I just give you the references and I'll move on to I was just going to take you quickly through the Commission in Italy case and then I'll give you the references. The Commission in Italy is a case that established the rule of EU primacy. It's interesting because it did so in the context of a multilateral agreement, i.e. an agreement that contained non-EU members as well. It's found in Bundle 5, tab 66. Bundle 5, tab 66. Page 2553, 66, tab 66. My lord, in this case, the Commission brought a case against Italy for imposing a new custom charge on the intra-EU states, which was contrary to Article 12 of the treaty establishing the European Economic Community, which became Article 25 of the TFEU. Italy's defence was that it was permitted to impose such a charge since the international agreement to do so was made within the framework of GATT, which is the General Agreement on Tariffs and Trade, which was concluded by Italy prior to its accession to the EEC. Italy said its agreement under GATT concluded prior to its accession, and concerned third states as well. So it was caught by Article 234, which is 351, which I showed you today. And we then come to the CJEU's decision, and I just want to highlight 2 points about it. If you could turn to page 10. At the bottom of page 10, my lords, you'll see that it says, in fact, in matters governed by the EEC treaty, that treaty takes precedence over agreements concluded between member states before its entry into force, including agreements, and I know you're going to say it's before, but I will show you the case after, but this establishes the rule of conflict and priority, including agreements made within the framework of GATT. Now, the last part of the sentence after the comma is of particular note, because it refers to the fact that the international agreement here arose out of the GATT, which is not just a treaty between member states, but includes third states as well. But this did not deter the CJEU, as you will see when you read the substantive paragraph above the section on costs. So, my lord, the CJEU in this case is confirming that primacy applied hereto, but only to the extent that the tariffs were being wrongly imposed between EU member states. Those same tariffs would still apply between EU member states and third parties. This may create a differential regime, but that did not impact the rights of third states. My lord, as I said, Commission in Italy spoke to primacy over conflicting intra-EU agreements concluded prior to a state's accession to the EU treaties. And here I will refer you to the skeleton. In paragraph 67.5 of Spain's skeleton and footnote 103, you'll see the cases that have come since, which confirm that the same principle also applies to any conflicting treaties concluded by member states, whether before or after their accession.
Sorry, I wasn't clear. 67. Your skeleton.
67.5 in Spain's skeleton and footnote 103. We've quoted them, my lord.
Do you want us to look at any of those?
Not in that case, my lord. I was going to take you now. What I was going to do now, my lord, having just given you an introduction to treaty conflict rules, that are international law rules on how to resolve conflicts, treaties, the rule applied in the EU, I want to take you to two texts, academic texts, that treat the EU law of primacy as an international rule of treaty conflict. The first one is the respected International Law Commission, and that is in volume 8. Tab 130. My lord, forgive me if your lordships are aware of what the ILC is, I won't describe it. But in case not, can I just give you a quick summary for those that don't know? The ILC is a body that arises out of the UN General Assembly. It is a UN organ that is charged with the codification and progressive development of international law. It is made up of members proposed by states and elected by the General Assembly, and includes in its membership leading international lawyers and diplomats. Its work is regularly relied upon by domestic and international courts, not always, but often, because it is seen as sometimes reflecting customary international law. And this much-cited report that I'm taking you to by the ILC was prepared by one of the world's leading international lawyers, Professor Marty Koskaniemi, with the input of several PIL specialists. It concerns fragmentation of international law, a much-discussed concept referring to issues caused by the way in which international law is developing various subfields that do not necessarily speak to each other. And the fragmentation report describes how these conflicts arise and provides a toolbox of techniques to determine how lawyers should solve them. And one of the tools available is obviously the conflicts rule agreed between treaty parties. And in that context, one part of the report speaks about the rules of conflict that may help bridge gaps. And if you turn to page 4034, My lords, you would have seen that the Supreme Court of Mika described Article 351 as an international law rule, even though it's in the TFEU. And this particular part of the ILC, we'll see, says at 283, which we've highlighted with the sidebar, agreements establishing international organizations often contain a conflict clause. The best known example is Article 103 of the Charter of the United Nations, likewise Article 307, previously Article 234 of the treaty.
That's now 351.
Exactly, my lord. And then it goes on, and that's a rule that I'm referring to. The treaty establishing the European Community takes absolute credit over agreements that member states have concluded between themselves. So that's not Article 351 because it's between member states. Do you see that, my lord?
But that's simply reflecting what is established EU law.
Yes, my lord. So I'm saying that it's in this report in the ILC because it is not just it's recognised as an international law rule, and I'm now going to take you to another text, which will also confirm. We say that this is not just a downward-looking rule, but one that applies as a matter of international law.
Can you really get anything out of what it says there? I mean, the author is just stating what is recognised as a law within the EU.
My lord, at some level, I suppose there has to be a faith here, but I would submit that the reason why this particular text on international law, as the book I'm going to take you to, discusses these rules, is because on a fundamental level, when you're talking about how one treaty applies vis-a-vis another, that can only be an international law conclusion. And that's why it's contained in this text and the one I'm about to take you to.
It may be contrary to international law.
What's that, my lord?
It may be contrary to international law.
My lord, but that's why I spent a bit of time, it seemed a bit odd, explaining to you that the ILC is a very respected body, and it may be, and it's for my friend to show you that that it conflicts with international law. I would submit, I've not seen anything that says...
Well, as I understand it, the EU is a party to the ECT.
Yes, my lord.
So, are you saying that as a matter of international law, it can unilaterally enter into other treaties to which other parties of the ECT are not party and override its treaty obligations?
My lord, but this is where it's
extraordinary.
Or its court can issue judgments which have the same effect.
My lord, it is really important that if nothing else, you would be absolutely right to show that condemnation if what the EU was doing was disapplying an obligation across all the member states that are signatories to the ECT. But it is only doing it as between the member states. As between the member state signatories to the ECT. That's why it's an intra-EU debate. If it was doing it beyond that, I would not even get up to make any defense.
And you say, well, the member states have agreed that between themselves.
They have, and not only have they agreed that, the CJEU is not speaking as we've decided today, this is what the rule is. They have been empowered by Article 19 to be a mouthpiece for the treaty. If, for example, all 27 states had written a document saying, and they're allowed to do this, subsequent practice, we say this is what the treaty means, as between us, then as a matter of international law, that is binding, because it is their treaty. They are the masters of their treaty. This doesn't have an impact beyond the member states. It is really important to understand that. You may still find it extraordinary, but it's not as broad as you think.
So just sort of developing it further. So suppose that all the member states got together, ignore general EU law.
Yes.
Suppose having entered into the ECT, they get together and say, we agree as between ourselves that the arbitration provision is not to be applied. You say, well, that should be recognised by us as meaning that in the relevant circumstances, the arbitration provision doesn't bite.
Yes, my lord. As a matter of the VCLT, you are allowed to enter into inter-se agreements, as they're called, between yourselves, and agree what the treaty means as between yourself, because it's your treaty, as between yourself. And that only becomes problematic if what they're doing, and this is my third question, is a treaty that cannot be divided up into bilateral obligations where you can neatly take them away. Because if it's multilateral, or if it's a collective obligation, you can't then separate off. Then you are harming the other non-members, and I will come to that in the third question. Well, can I take you to another text, which is volume 8 and tab 141. It's the same volume. Well, this is a leading text on the VCLT and treaty interpretation. If I could ask your lordships to turn to page 4236.
We looked at this yesterday, I think in another visit possibly.
Yes, you did, my lord. I showed you the chapter on Article 30, just to make the point. And I'm doing this because a judge proceeds on the basis of conflict rules can only really be found in Article 30. I hope, well, I'm trying to show you that that's not true. And Lord Justice Newey, the question you asked is addressed in respect of the EU in page 4236, the interagreements between the member states. If we could read it together, my lords, or you can read it on your
Shall we
own.
read
right?
it to ourselves? It's quicker, I think.
Yeah. My lord, the part is from however. The TFEU and TEU and TFU impose legal constraints on the scope and content of inter se agreements between EU member states. These constraints concern not only their limited competence to conclude international treaties, but also their lack of power to derogate from EU law. If the ECJ, now the CJEU, declares an inter se agreement incompatible with EU law, member states must terminate the agreement, according to Article 4. But even before termination, its provisions are not applicable in relations between the parties to the inter se agreement. And then it cites exporter, which is one of the cases in the footnote I mentioned about EU primacy. In other words, the ECJ does not tolerate the relative validity of inter se agreements, as foreseen in Article 30, for the residual character, which means it's referring back to its discussion that it doesn't complete.
In a sense, it's the other way around here. You say the TFEU is the inter se agreement.
No, my lord, I'm saying that the inter se agreement is the ECT in respect of each member state.
But in a sort of way, maybe I'm misunderstanding, in a sort of way, you're saying, well, so be it, you've got this international agreement, but that doesn't stop some parties to the agreement reaching an agreement between themselves. And effectively, that's what's happened because they've signed up to the EU.
My lord, what I am saying, that the inter se agreement in this context is the agreement, essentially the ECT is a series of bilateral obligations to allow for arbitration. And those agreements in between with each other are the inter se agreement that are conflicting with the EU treaties.
How can it be inter se if the EU itself is party?
I know, but it's not. It's inter se because what's being disapplied is each member state's promise to another member state, that's the inter se agreement, to allow the investors from the other member state to pursue arbitration under Article
That's
26.
that's also an agreement with the EU.
Yeah, if the EU has accepted the treaty, the EU has accepted that the parties to the treaty, including all the member states who signed the treaty, may arbitrate any disputes.
My lord, absolutely. But what this passage and others show you, I'm not trying to suggest to you that that's not what was agreed. What I'm trying to show you is that subsequently and subsequent practice can mean, because of the way treaties are made, that some treaties that were concluded prior or even are disapplied.
Can I just ask you this question, and then I think we should let you get on with citation of whatever else you want to cite. But what I'd like to know is that given that the EU accepted the ECT and with the consequence that I've just given you, is there a decision of the European Court of Justice, the CJEU, that says even though the EU has accepted the ECT, the arbitration provision of the ECT is disapplied between member states of the EU?
Yes, my lord. Can I take you to Comstroy?
Right.
It's
It's on this very treaty, is it? Yes.
yes, my lord. A6,
Yeah.
bundle 6, tab 75.
That's where I thought we were going some time ago. Okay.
My lord, in order to keep my submission, I had built on what the judge below had accepted. He'd accepted that the CJEU and had proceeded on the basis that there is a conflict with the ECT, but I'm happy to show it to you.
Where again?
It's tab 6, bundle 6, tab 75.
Yes.
And paragraph 66, page 2808. This is the case of Comstroy. My lord, in my introduction yesterday, I'll let you read it, but in my introduction yesterday, what I was saying was that ACMEA was the foundational decision that announced or declared the conflict with the bilateral investment treaty and its inapplicability. The question then was, well, does that apply in the multilateral context? And Comstroy was one of the answers to that. And there's no doubt. Sorry,
go on. I mean, I did look at this again, and you're quite right in what it says. I haven't quite followed how the question arose, since there was a dispute between Moldova and the Ukrainian company. But anyway, it doesn't matter.
It's absolutely, my lord. You're right. And then there's been a subsequent opinion, but there can be no doubt, and that at least as far as the EU is concerned,
yes,
this also is a conflict with, and that's why the judge accepted it, despite his.
And I think somewhere there in the bundle there's EU stuff telling the member states to get out.
Yeah. So there's no doubt about that. The question, as I said, is always, does this make any difference in international law? My lord, can I?
Yeah.
My lord, I just want to summarize where I am now. And if you're not with me, just based on the sources I've told you, I'm going to then take you to Article 5, which I think makes it very clear that what the CJEU's practice is on this issue has to be treated like an international rule of interpretation under the VCLT. But can I just summarize what I submit, what I was trying to show you? The first is that the principle of primacy applies in international law context to give primacy to the EU treaties over conflicting international agreements between member states. And I submit primacy is a rule of international law, and the text I showed you yesterday showed you the breadth and the different ways in which member states can formulate their conflict rules. They can be in a treaty, they can be in practice, and in this case they are in the decisions of the CJEU, who has been empowered to give treaty interpretation. Secondly, my lord, the fact that this principle of conflicts is not in either the TFU or the VCLT does not matter, because conflict rules, as I said, can be outside it. But if you're not with me on that, my lords, there is another international law provision I'd like to show you, which is Article 5 of the VCLT, and that's in Volume 7.
Yeah.
Tab 101.
Sorry.
Tab 7, 101. Excuse me. Well, then it's page 3405 and Article 5. see that, my lord? My lords, under treaty law, there is a special category of persons described as international organizations, and the EU is a very prominent example of that. And as you can see, Article 5 explicitly says that the VCLT rules on conflicting treaties, interpretation, or any other thing without that the EU has as a rule of interpretation that it applies, is without prejudice to the rules of the international organizations such as the EU. So the VCLT's own rules, the EU's own rules, take priority over the VCLT. My lord, and those rules can be quite broad and include decisions. If I can just take you back to Professor Schmallenbach's extract, it's in volume 8, tab 141, page 4233. Volume 8, tab 141, page 4233, and you'll see, my lord, at the bottom, the primacy of the rules of the international organization. According to Article 2, the VCLT, the phrase rules of the organization denotes the constituent instruments, derived decisions, and resolutions adopted within the international organization in accordance with the constituent instruments and the established practice of the organization.
I'm very sorry, I can't find where you're reading from. It's page...
Sorry, my lord, it's page 4233.
Yes.
At the bottom, underneath the primacy of the rules, under the heading. Apologies, my lord.
Yes, thank you.
Get in the attack.
Sorry.
And it says, the lex specialis character of constituent instruments derive rules case law, that's in 16, practice of the international organization in relation to the convention is preeminent with respect to the interpretation and amendment of the constituent instrument.
Can I just understand the significance of this? So Article 5 says, in effect, that the convention applies without prejudice to the rules of the organisation. So the rules of the organisation take precedence over the convention. But which bit of the convention are you trying to get out of?
I'm not. What I was trying to show you, my lord, is the judge, the way he approaches it, is as if he doesn't. We did make submissions on Article 5. Was as if the VCLT rules, when it comes to Article 30, the treaty conflict or interpretation. And what I'm trying to show, I'm addressing 2 points. Well, the main point I'm addressing is that even if you dismiss the EU practice as just being about EU law, Article 5 in the VCLT tells you that those rules are not just domestic rules, but that's how those are international rules as well of interpretation.
Well, they tell you that they trump the convention, but you're not trying to trump the convention. There's nothing in Article 30 you're objecting to, is there?
Well, my lord, that doesn't apply. That's not the conflicts rule we're applying. We're applying the special conflicts rule based on the case law, and that is a rule of the EU as expressed by the CJEU. And we are told by Article 5 that those rules of interpretation are to be treated like international rules for the purposes of interpreting the relevant treaties.
But it doesn't say that.
Then it does say that.
My lord, it wouldn't. It's saying that when you're trying to interpret the constituent instruments, you look at the rules of the EU, or the rules as expressed by the CJEU, are what apply. It wouldn't need to say that, my lord, if they were just domestic law points.
But at the same time, I mean, it says the convention applies to any treaty adopted within an international organisation. So the convention applies to the TFEU.
Yes.
Without prejudice to any relevant rules of the organisation.
Yes.
Now, I'm not quite sure how any of this helps. I mean, I dare say the EU would be absolutely appalled by the idea that the convention should be used to interpret the TFEU or the TEU or anything else.
Yeah. My lord, you see, if the question is, as it has been, and especially the theme of the judgment, that all these things you're telling us about what the EU does, and my learned friend says it repeatedly in a skeleton, these are just domestic law points. What Article 5 confirms is that the rules that are made by the constituent, by an international organization about how treaties are to be interpreted and what their impact is an international law rule. Then the question is, how does that interrelate to the VCLT? And it says, actually, they take priority over the VCLT. And the two rules here are that the CJEU gets to interpret the treaties and the treaty relationships of the EU member states. And two, by way of its practice, which is also a rule, the CJEU has told us that the TFEU, when it comes to conflict, takes priority over conflicting treaties.
Is the ECT part of EU law?
My lord, actually it is, and it's the Conroy decision says so, that as soon as the EU signs up to a treaty, it becomes part of the EU legal order.
So why does that not remain binding?
Sorry, I'm big.
Or why looking at an outsider to it all, why do we proceed on the basis that the ECT is overridden by subsequent EU treaties?
My lord,
And the EU could succeed from the ECT, presumably. If it wanted to.
my lord,
It has-
it hasn't, my lord. But they are in the process, the states are in the process of doing that. But one of the reasons,
all the more.
well, my lord, it may seem very unusual from one perspective, but that Schmallenbach extract I showed you said that you should immediately terminate, but before you terminate, those provisions are inapplicable. That is how international law works in this context. It may seem odd, especially when we look at it from a private law perspective, when things are much more organized and there's some sort of mutual exclusivity between certain remedies. But certainly in the international law context, it is not unusual for disapplication to happen before termination. That's what that extract says so in terms.
We could take the view, could we not, the CJEU is wrong?
My lord, and I would submit you cannot do that because it is an authentic interpretation. We were about to add.
Well, it's an interpretation of a treaty to which this country is party, and we are not bound by CJEU interpretations of the treaty to which we're party.
Well, my lord, if you take the view that it's just another court or where I'm trying to present you as the Supreme Court in this context, it's not. If you see it as a mouthpiece of all 27 states, as in the 27 states have given you a statement, this is what my relations mean, that is an authentic interpretation that as a matter of international law, under the VCLT, 31(3)(c), 3A, you cannot go behind.
Hang on a moment. It's. Yeah, just repeat that last.
My lord, I'm going to, if I may, just share some extracts with you on this.
See, I'm interested in the answer to my lord's question because I mean this is really the basis on which the judge rejected this argument, isn't it?
Well, actually,
Looking at paragraphs 120, sort of 122 to 125 of his judgment.
my lord, quite the opposite, if I may say so. The one thing he did do, which we haven't appealed, he recognised there was a conflict. Where he disagreed was, so he recognised that's what the CJEU says. He was invited to go behind the CJEU's reasoning. He did not do that. He accepted there was a conflict. He accepted what the CJEU said, but where he disagreed was whether that had an international law effect.
Exactly.
So, but that doesn't mean that he, well, my lord, I thought you were referring back to
No, that's exactly the point I'm making.
Yeah.
He, the judge, didn't think.
Yeah.
I thought the point you just made was that the judgments of the CJEU have an international law effect, which this country has to give effect to. Too many effects there.
My lord,
I'm simply making the point that that's at least one of the issues on which the judge found against you.
quite right, my lord. And we say that was not correct because despite extensive submissions on Article 5 and treaty conflict rules, that is not the correct conclusion to come to.
Okay, where do you want to go now?
I wanted to. Are you ready to do that? I'm just going to answer your question about whether you can go behind them.
What's this?
It's to answer the question about whether you can go behind the CJEU reasoning.
It's not a question of going behind the CJEU reasoning, is it? The question that my lord put to you and I'm putting to you is whether this court is bound by decisions of the CJEU in circumstances where we're no longer member states.
I thought Lord Justice was asking what if we think they're wrong.
I'm not sure it really matters on what basis we
Yeah,
don't
quite.
Well,
follow the decision.
okay. Well,
I mean, the judge was clearly of the view that he was not obliged to follow the decisions of the CJEU. So he didn't need to decide whether it was right or wrong.
yes, my lord. And our submission that the rules on treaty conflict were not properly applied by him, because had they been, then we say, as a matter of international law, Article 26 is disapplied.
I'm not sure this really helps, but I was looking at what the EU declaration in relation to the consequences of ACMEA, which is at tab 111. I don't think there's an equivalent one following Comstroy's there, but I assume the same idea.
The same idea.
And you do get very clearly what the EU position there is, at page 3720.
Exactly.
Union law takes precedence. As a consequence, all investor-state arbitration clauses contained in bilateral investment treaties concluded between member states are contrary to union law and thus inapplicable.
Yeah.
So, as between the member states, they are bound by the proposition that the arbitration provision to which they agreed in the ECT is inapplicable.
All right, but my lord, it's not just they're bound by a decision. That is a interpretation given about
The treaty to which they have subscribed through the TFEU now means that the conflicting provision of the ECT is inapplicable.
Yes.
That's what they've agreed between themselves.
Exactly. And so if an investor from a non-EU member state, which is a signatory to the ECT, sues Spain, that's fine. But if it's another EU investor, that is not fine. My lord, on Article 5, I'm conscious of the time, there's still a lot to get through, including telling you why we say the judge was wrong. Can I just say that you have the note? This Article 5 argument has also been developed in an academic article quite recently. It's by Dr. Gott. It's in Bundle 9, tab 149, page 4420. I don't, given the time, I don't intend to take you through it, but you can have a look at it.
Sorry, tab.
Tab 149, and it's page 4422. The summary of what he's saying is in the second paragraph of that page.
Yep, okay.
My lord, so I wanted to, because I've been promising it, just show you something on disapplication, because that does sound very unusual, but as I said, in the international law context, it isn't. And there's a very nice description, if I may say so, as to how that interrelates to words validity. And if you could. It's in Bundle 8, tab 132. page 4069,
Sorry,
tab 132.
Yeah. Okay.
And also, the VCLT does not speak of treaties or provisions being invalidated or terminated in order to resolve the conflict, as I showed you when in the few rules it has about treaty conflict. Rather, the rules state that the treaty is applied or disapplied to the extent needed to resolve the conflict. And the language of disapplication as opposed to validity or invalidity is quite deliberate. And there's a nice, there's a pithy description of that on this page in 113, the second paragraph. International law then has, as page 113 internal, has a structural problem with validity and invalidity, and it might be useful to unpack its various elements. First of all, there is a strong presumption of validity. It is generally presumed that treaties, e.g. are legally valid, and it could hardly be otherwise. Admittedly, the Vienna Convention on the Law of Treaties envisages a number of circumstances which could be invoked as grounds for the invalidity of treaties, but it is abundantly clear that those circumstances play a minor role. As Tony Ost put it, with some aplomb, the subject is not of the slightest importance in the day-to-day work of a foreign country. Indeed, he does not recall during more than 30 years of practice a single serious suggestion that an existing treaty might be invalid. And then, my lord, if you turn to page 117, in the second paragraph, he talks about the conflict rules. These antecedents notwithstanding, the regime as laid down in the Vienna Convention on the Law of Treaties does not anticipate the invalidity of any treaty in case of conflict. Article 30 speaks merely in terms of prevalence and applicability, thereby suggesting that the validity of a treaty found incompatible will not be at stake. Much the same is suggested by the circumstance that treaty conflict is not listed among the possible causes of invalidity of treaties in Part 5, Section 2, a list which, moreover, is deemed to be exhaustive by virtue of Article 42. In short, according to the general law of treaties, as reflected in the Vienna Convention, a conflict between two treaties may result in one of them being left unapplied for a while, possibly indefinitely, which is the case here, my lord, hypothetically, but will not result in invalidity of the treaty. Well, that was just an explanation of how disapplication works, and it's not quite correct to say that the treaty itself or the provision is invalid, because as I said, it remains valid in between a non-EU member state investor and the EU. And well, then, can I talk about the effect, retroactive or prospective? The broad chronology, and that's the second question, is as follows. The ECT entered into force for Spain on 17th December 1998. The TFEU entered into force for Spain on 1st December 2009.
It said 98, I think it was 97 actually.
I've got here 17th December 1998.
Well, the date that I've got, it was ratified by Spain on the 16th of December 97.
But it entered into force, my lord, later. It's a separate concept.
So it entered into force
on 17th December 1998. The TFEU entered into force for Spain on 1st December 2009. The ISL parties lodged their notice of arbitration under ECT Article 26 on 22nd November 2013. The CJEU identified a conflict between TFEU Articles 267 and 344 and investment treaty dispute settlement clauses on 6th March 2018 in the ACMEA judgment. Please tell me if I'm going too fast, my lords. The CJEU identified a conflict between the TFEU Articles 267 and 344 and investment treaties on 6 March 2018 in the ACMEA decision. The CJEU confirmed, as if confirmation were needed, that it considered the logic of ACMEA to apply to the ECT as well. And that's a Comstroy decision I took you to, my lord, on 2nd September 2021. Well, now, if the TFEU ECT conflict identified by the CJEU in ACME and Constroy only took effect from the date of either judgment, that would mean that there was a valid arbitration agreement under the ECT Article 26 at the time the arbitration commenced. The ISL parties' notice of arbitration predated both judgments. But it is well established, and I don't think disputed, but my learned firm will correct me if I'm wrong, that the judgments of the CJEU have what is called ex tunc effect, applied not from the date of the decision, but from the date when the conflict first arose, which at the latest is when the TFEU came into force in 2009. In that way, the CJEU decisions have retroactive effect. And given the time, I won't take you to a source confirming that. I said it's not disputed, but to the extent you would like a reference, it's in the case of PL Holdings in Poland, the CJEU confirming ex tunc effect. It's A6, tab 76, para 58.
It's not disputed. We don't need to do it.
I thought your explanation to us was that the CJEU is effectively speaking on behalf of all member states in this context as a matter of international law.
Yes, my lord.
So you can only surely speak on behalf of all the member states when you speak.
My lord, that's correct, but you are entitled to say that this declaration that I'm giving you on behalf of the 27 states applies as of this date. You have complete freedom as to what your statement means, what the treaty means.
Well, that means that would mean that some arbitrations which were wholly completed before that date would become retrospectively invalid.
I know it's important. I'm glad that you asked that question. What we are inviting you to do is not to remove Spain's immunity. We are not asking you to set aside the arbitration, because Article 9, Section 9 of the SIA, is an exception that our friends opposite are using to say Spain doesn't have immunity. Your conclusion that it does not mean that the tribunal, you're setting aside the award. We're just asking you to set aside the registration award.
But
The
the logic
registration
of your
order.
case, as I understand it, is that there is no valid award.
Yes, but that's not what I'm inviting you to determine, because for your purposes, all you've got to decide is, was there a valid arbitration agreement at the time? I'm not saying now, please, because they could go to another country with the same arbitral award with different rules of immunity and try and enforce it. That's the difference. If I was asking you to set it aside, there'd be an interesting question. What happens to an award that's been set aside in England in another country? What I'm asking you to recognize is that the arbitration agreement under which this award was commenced was disapplied. You may say is a distinction without difference.
Well, it is a distinction without difference, because as my lord put to you, the effect of what you're asking us to do is that there was no valid award.
Well, my lord, yes, perhaps for this country, but the award still exists. It's not a philosophical point. As I said, they could go to another country which has different rules of immunity and try their luck there. But I'm not asking you to set aside.
We could never bind another jurisdiction.
What's that, my lord? Potentially, but
We could never bind the courts of another jurisdiction.
well, my lord, it depends on the rules of estoppel. Not everyone follows them, and not all jurisdictions have the same rules on res judicata.
Right. Anyway, I suspect that the transcriber would like a 5-minute break.
Yes.
You nearly done. What was that? We were thinking Malone Friend might land around. I don't want to pressure him at all. But if he's only got a couple of minutes to go, I'd love a break just before I start. But I'm very happy whatever works.
My lord, I don't have a couple of minutes to go, but I'm not far off. I need
Well,
about.
if you think you can finish in the next 5 or 10 minutes, let's just get on with it.
My lord, I need about 20, 25 more minutes.
Well, in that case, we'll have a break now.
And I apologise.
Progressive EU.
Sorry about that.
I'm totally relaxed. I just didn't.
I need
No,
to.
no, take the time you need. I just didn't want.
No, you did the right thing, but I don't want you to
embarrass
reaching
by
out
having-
to our.
No, not at all. I mean, slightly more questions than perhaps we get.
No, well,
That's fine.
no,
I'm totally relaxed. I just didn't want you to have the embarrassment of breaking for 5 minutes and come back. Okay. We could have done, you know. Thanks, Pat. Not at all.
Yeah, because the only person really going to lose is going to be a lawyer. So.
Yeah, I can very close to say agreements literally.
They called me yesterday.
Abrasive eagle.
Thank you for the break, my lords. Just my third and final question that I was going to address, and before quickly moving through the, why we say the judgment is wrong. And the third question, my lords, was can the reasoning I spoke to you about EU primacy apply to a multilateral treaty such as the ECT? In other words, can it be said that the TFEU has primacy over intra-EU disputes under the ECT, but not those involving non-EU member states? Is that a problematic conclusion, even if you accept that the EU primacy rule is a rule of international law?
Well, in your case, Comstroy decides that point.
Well, it does, my lord, but I wanted to also show you that as a matter of international law, it is perfectly unexceptional for a group of state parties within a multilateral treaty to come to an agreement, or even conflict rules to apply just between those parties. And Article 34 of the VCLT is an example of that, where it says that a conflict rule can apply just between the parties to a multilateral treaty, as between those parties.
Okay.
My lord, and the reason that is the case, and it's a case, and it can be a case in this, and the theoretical underpinning of that, is because the difference between a bilateral and multilateral obligations. Article 26 is a classic, we submit, bilateral obligation. And if I can just just explain the difference somewhat. Bilateral obligation obviously is in which a party owes the obligation to each other party treaty. These can individually. And then there are collective obligations where each treaty party owes the obligation to all other treaty parties as a whole. They are not contractual in character. They cannot be divided into bilateral components, but are more like criminal law statutes or even constitutions. The significance, as a matter of general international law, as I said, it has no problems with allowing inter-se agreements in relation to bilateral obligations, provided third states are not affected. And my lord, there is an established approach to distinguish between multilateral and bilateral obligations as a matter of international law. If I can just take you to that, it's volume 8, an article by Professor Powlins, tab 128. Volume 8, tab 128. If I may ask you to turn to page 4000, under page 4000. And the little table there. So, my lords, it's a typology of international obligations. It flows from common sense, I hope, but let me just explain it quickly. The bilateral obligations are on the left and include multilateral treaties that are bundles of bilateral relationships. That is what Spain says Article 26 of the ECT is. And then on the right, you have the types of things that fall into the category of collective obligations, so-called interdependent obligations, where all the states are considered to be injured if they are breached. And then so-called integral obligations of immense importance, such that every treaty party has a collective interest in ensuring that every other treaty party complies with them. So human rights and humanitarian obligations, and in the 21st century at least, climate change obligations. And finally, you have treaty prohibitions that reflect norms of jus cogens, the unbreakable rules of international law, such as the prohibition on the use of force and genocide. We say, my lord, that the ECT Article 26 is none of these. Had it been, then you may have said, well, I find it hard to see how you can disapply, because you really then are affecting third party states. But there are two, when you're applying this approach, there are 2 points to note that Professor Powlins talks about. The first is that the relevant question here is not in the context of the ECT as a whole, whether the ECT as a whole is bilateral or collective. If you can turn to page 4002, you'll see at the top there, my lord, in his preliminary remarks, the second sentence, one must examine, he's talking about the WTO, but it's the same principle, it's a typology of multilateral obligations. One by one, must examine the nature of the WTO obligations one by one to determine whether they are bilateral or collective. As the IRC commentary noted, it will be a matter for the interpretation and application of the primary rule to determine into which of the categories an obligation comes. Hence, some WTO obligations may be bilateral, others collective. So, and I'm saying this partly because, with the greatest respect to the judge, he misunderstood that. You don't have to determine, is this treaty bilateral or collective? It's a document that has a collection of bilateral and multilateral obligations. And secondly, my lord, if you look at the fourth paragraph, he also rightly notes, when it says third, when it comes to distinguishing multilateral treaty obligations of a bilateral nature from those of a collective nature, the starting point or presumption is that treaty obligations are normally of the bilateral type. My lord, of course, that, and my lord, there has been an analysis of sorts done on the ECT, and I just want to show you that before I move on to explaining. And that's in the article by Professor Azaria at UCL. Same bundle, sorry, I had to put it away, in tab 137. That's bundle 8, tab 137. My lord, she builds on the work of Professor Paulin's, and the reference that I wanted to take you to is page 308, internal page 308, bundle page 4168. And it's the last paragraph. My lord, the ECT is not just about providing an investor protection regime. That's just one part of it. And what she says there, as you can read, is that seen through these lenses, the ECT investment protection obligations, which are the ones that are invoked by an investor when they commence an arbitration, rest on the foreign nationality of another contracting party and on a predominantly individual interest of each contracting party to see their nationals protected abroad, rather than on a community interest that involves the protection of all corporate entities within their jurisdictions. They are bilateral obligations.
What if you had joint investors, one of whom is an EU member state national and the other is not?
And it was a single award.
It's a joint claim.
It's a joint claim. My lord, you'll have to wait till the Opera Fund case, which is in the courts right now on that very question. Spain's position is that immunity, it depends on how the relief is framed. If it is framed to say that the EU member state investor gets 50,000 and the non-EU member state gets 30,000, then, sorry. Yeah, we would say that the immunity in relation to the EU investor and what they're claiming is not possible because there was no arbitration agreement for them to pursue their claim.
No, but that's not the point of the question, is it? The question is whether or not it can have an effect on non-EU. Is it right to say that this doesn't have a multilateral effect?
Yeah.
Because if you're right, the prevention of the EU partner arbitrating will impact upon the non-EU partner, won't it?
Well, not my lord, because a non-EU partner can proceed and bring their claim.
Well, that depends on the nature of the claim, doesn't it? What if it's a joint and not several claim?
My lord, then it is quite possible for the investor who can bring the claim to pursue the claim. They can transfer the rights. I'm even finding it hard to conceive of why the non-EU member investor cannot pursue the arbitration in their own right.
Well, let's say you have a consortium of investors.
Yes.
Say 20 investors, 10 of whom are EU and 10 of whom are not.
Right.
I mean, it would be a nonsense to suggest that you have an arbitration for the 10 and not for the other 10.
Well, but my lord, you with the greatest respect, you may consider that nonsense, but it floats. that just flows from the disapplication of the arbitration agreement vis-a-vis the 10
That shows-
EU member states.
But what it shows is how that is going to impact upon the non-members, because rather than being party to a single arbitration with all the investors joined in, you will have to mess around with the nature of the claim and of the evidence and of the parties to the arbitration.
I think you're
All because the EU members have agreed amongst themselves that they will not play ball.
well, my lord. What my lord is talking about is the inefficiency rather than the character of the obligation. The obligation.
Why doesn't the inefficiency indicate that this is having an effect on the non-EU members?
Because my lord, the inefficiency doesn't make a bilateral obligation multilateral. It's a bilateral obligation between the states. I am promising another state's investor that they can bring an action against me.
Why aren't you promising both the EU and the non-EU members that they can bring an arbitration against you?
My lord, I am doing that individually. It's not a collective obligation. I'm individually in the arbitration agreement saying that investors from Kazakhstan, Spain, Germany, and other EU states, you can all bring an arbitration against.
Can jointly bring an arbitration.
My lord, the arbitration agreement doesn't say it can be jointly brought, but even if it could,
Why? What if they're joint investors?
well, they can be joint investors, my lord, but that doesn't make the arbitration agreement vis-a-vis the individual. My lord, even in the normal situation, a joint investor is not entitled to take advantage of the fact that one of the parties has an arbitration agreement and it does not. I think so if I'm a joint investor with another party, what you're saying is it's unfair that one of them has an arbitration agreement and the other one does not. That's just,
They're all party to one contract with one arbitration agreement.
well, my lord, that's the contract, not the ECT.
No, but you're saying in an ordinary arbitration situation.
Yes, in an ordinary arbitration,
All parties to one contract
right,
with one arbitration agreement.
right,
Well, here we're replicating that with one treaty,
right.
which provides for arbitration. But you're saying that the EU members can say, you non-EU members cannot bring a single arbitration with all the other investors because those 10 investors can't join you in that arbitration.
My lord, if the arbitration agreement is not available to some of those joint investors, then I don't see why, because it's available to others, it becomes unfair or harmful.
Well, I thought you said it could create inefficiency, and that's unfair and harmful.
Well, my
all
lord, but it
sorts of
doesn't-
situations in which the absence of the EU investors and their witnesses might damage the prospects of the non-EU investors in succeeding in the arbitration.
My lord, but that is about when I've called it efficiency, about how you can run an arbitration well or
You
not.
can have multiplicity of proceedings and the risk of inconsistent decisions, both of which are contrary to fundamental EU principles as reflected in the various conventions.
My lord, but it doesn't harm the Kazakh state or the non-member EU states that an arbitration cannot be run as efficiently as one would like. And the analysis I showed you, I would respectfully submit that a bilateral obligation does not become multilateral just because it's hard to bring a joint claim. If the arbitration doesn't apply in relation to some of those investors, then it doesn't apply. It doesn't become unfair because some of them can bring it and they can't make use of the witnesses for the EU member parties.
Yeah. Okay. Right.
Can I just quickly go through why we say the judge was wrong? My lords, we have to be a bit express here, and I apologise, but in the time. My lord, his analysis on this question is at paragraph 78 to 87, and I just to have it open as I walk you through. Paragraph 78. My lords, paragraph 79 and 88 are about how Mika precluded him from even looking at the question. I've already addressed that, so I'm not going to in the short time available. You will have a view on that. My lord, from 81 onwards, he says that he is precluded by ICSID and Mika from assessing Article 26 question. As I said, I've already explained that to you. Sorry, my lord, I'm just rushing through this. So I don't need to talk about that. My lord, in the same paragraph in 81, you'll see that he says, however, even if I'm wrong in the analysis, which is that I'm precluded to even look at the question, applying conventional analysis to conflicting treaty obligations, one would turn to the Vienna Convention. So the first point, my lord, is that it's our Article 5 argument is in the Vienna Convention, but is never considered. So you have that before us, and I think he got that. He doesn't even analyse it. But our primary case is based on pure principles of international law on treaty conflict, the various extracts I took you to, and the rule of primacy. And that sits outside, as it were, the VCLT in that sense, because it's based on the cases. My lord, in paragraph 82, he sets out Articles 26 to 30 of the VCLT. My lord, no part of Spain's case relies on that and never has done. At paragraph 83, he cites Articles 40 and 41 of the VCLT. Again, my lord, no part of Spain's case relies on that and never has done. And then, my lords, at paragraph 84, he refers to the distinction I just took you to. He approached it incorrectly, my lord, the multilateral and the bilateral point. He says that both the ICSID Convention and the ECE are plainly multilateral treaties. Mr. Barros drew attention to the bilateral nature of the dispute resolution procedures in the ECT, which only involve the two parties. He submitted that such a procedure is a bilateral process. That may be, but I do not consider that the fact that the only two parties would be in dispute means that the treaties should be construed as though they were bilateral. And well, that is incorrect, because we were not submitting, and I'm not submitting before you, that a bilateral obligation, a treaty is a collection of multilateral and bilateral obligations, and that's lost. Obviously, if I was saying, please treat the whole ECT as bilateral, that is wrong. It's only a collection of multilateral and bilateral obligations. And for the same reason as the other provisions I referred to, in paragraph 84, he refers to VCLT articles 31, 32, 54, and 58. Spain's case on the disapplication of Article 26 does not require interpretation under Article 31. Recourse to supplementary means pursuant to Article 32, termination under Article 54, or conclusion of an inter se agreement under Article 58. Disapplication is a result of a treaty rule that is imposed, not imposed from the outside. We're not trying to interpret our way out of Article 26, but disapply it. And also at paragraph 86, when the learned judge says that in terms of treaty conflict, this is governed by Article 30, we obviously disagree. That was never our case, and it isn't our case before you. And then at paragraph 307, at paragraph 86, the judge describes Spain's argument is circular in the second half of it. See, Spain would probably argue, can you see that, my lord? I think fourth sentence, Spain would probably argue that this is a circular argument because of the need for a valid ICSID award, and if Spain were right, such an award would not be valid because there is no valid arbitration agreement. But the answer to that is that such reasoning is itself entirely circular, because if one considers the matter in a chronological and linear fashion, starting with the ICSID Convention itself, Spain acceded to that freely and did so, and so did the United Kingdom. Spain, or any other member state, in my judgment, cannot rely upon ACLIA and or the Constroy cases to dilute the United Kingdom's own multilateral treaty obligations. It certainly cannot rely upon those cases to interpret the 1996 Act differently. My lord, there are, based on our submissions, with respect, this is not correct. ICSID does not, as I've said, contain the arbitration agreement. It is another instrument, in this case the ECT, and it's a matter of international law we submit, that is the law governing that instrument. The arbitration agreement is disapplied and cannot give rise to an arbitration agreement, and ICSID does not preclude such a conclusion from being reached. Neither are Spain's or any other member state's obligations breached just because the arbitration agreement in the base treaty is disapplied. England is not, the UK is not breaching its treaty obligations under the ECT by recognising, as a matter of international law, that Article 26 is disapplied as between the EU member states. And finally, my lord, we come to the concluding paragraph that I started my submissions with, and that's at paragraph 87. My lord, I took you through this paragraph earlier, and it's really the last part of it where it starts, however, in my judgment, about 3/4 of the way down. However, in my judgment, my lord, you may have to read it in your time again, given the time, but can I just tell you what we consider to be the problems with this passage? First, the judge continues to misunderstand Spain's treaty conflict case. His lordship continues to state it is about a conflict between EU treaties and ECT, but it's also a conflict with the ICSID Convention. But as I've already explained, no part of Spain's case concerns a treaty conflict with ICSID. Neither does what Spain is arguing result in a conflict with ICSID. Second, Mr. Justice Fraser seems to think Spain's argument is dependent on interpreting the ECT. It is not. It is dependent on determining whether the relevant states, in this case Spain, the Netherlands and Luxembourg, have agreed to disapply them inter se. Disapplication is a specific outcome. It is not interpretation, it is not termination, and it is not invalidity. And he talks about interpretation at paragraph 101. I won't take you to it, but just for your reference. So my lord, Spain relies on a supervening rule of international law, the special conflict rule, or via Article 5 to argue that ECT Article 26 is disapplied. And Mr. Justice Fraser there almost mischaracterizes Spain's case as seeking to impose disapplication of Article 26 to all states, I'm quoting him. This is not what Spain is arguing. As I've shown, Spain's argument is that disapplication would only occur as between the EU state members of the ECT. His lordship also speaks in this passage about the CJEU having primacy over other states' obligation. This is a theme he repeats elsewhere, where he comments that Spain's arguments elevate the status of these decisions of the CJEU, and that's at paragraph 67, almost as though they were decisions of an overarching international court. This is a misstatement, my lord, of Spain's case. The CJEU's role in Spain's case is not like a court, as I've said, but rather a designated body under the treaties charged by all 27 states to pronounce on their treaty relationships in certain situations, such as when they conflict with the EU law. And the CJEU's decision has effect in international law and the treaties, not because it is a court, but because it reflects what all 27 states have decided in respect of their treaty relationships in this case. My lord, for all these reasons we say that Mr. Justice Fraser was wrong. My lord, I was then going to address what the ISL parties say, but I can reserve that to my reply.
We should leave that.
And I have no further submissions to make for the moment, unless your lordships have further questions.
Can I ask you one thing? You've said a number of times that the arbitration isn't pursuant to ICSID but pursuant to ECT. But the ECT provides that one possibility is an ICSID arbitration. Once the parties request arbitration through ICSID, aren't they then engaging the request for arbitration provisions in ICSID?
Well, yes, my lord, but the
Why isn't that an ICSID arbitration?
it is, my lord, the point I'm making, I'm sorry if it wasn't understood, is that the ICSID regime itself doesn't furnish the arbitration agreement. Our conflict is with the ECT and the provision of the arbitration agreement there. And if that's disapplied, then ICSID doesn't even come into play. So what I'm trying to explain is that
The arbitration agreement is formed by the request for arbitration.
my lord,
That's the conventional view of how an arbitration is commenced.
my lord, it's actually it's formed by accepting the unconditional consent in Article 26. It doesn't have to be ICSID or the arbitration agreement arises out of the acceptance of the offer of arbitration under Article 26. And if that doesn't exist, then the ICSID regime doesn't come into play.
Yes, but if it does, you then have to make a request for arbitration, don't you?
Yes.
Why doesn't that engage the provisions of ICSID in relation to an arbitration agreement?
My lord, I'm not saying ICSID isn't engaged, but that's the next stage. What I'm submitting is that the conflict that I'm talking about to you today is between the ECT and the TFEU. If we are right on that, then the next stage, which is an ICSID arbitration, does not even happen. So we're not conflicting with ICSID. ICSID, it's perfectly consistent with ICSID to say there was no arbitration agreement, therefore the arbitration that you began under ICSID does not get to happen. I'm not saying there's something wrong with ICSID or that there's a conflict with an ICSID provision.
Parties don't have to use ICSID.
No.
But they did.
Yes. To put it differently, my lord, it's not a breach of the ICSID Convention if you agree that the arbitration agreement or the arbitration offer was disapplied. There is no way you can start an ICSID arbitration. That doesn't breach ICSID. That's all I'm saying.
Can I just ask you one other thing?
Sure.
The way you put your case is that Article 9 is the only route for avoiding state immunity.
When it comes to the enforcement proceedings for ICSID, yes, because we say, yeah, sorry, please go ahead.
And your only answer to that is the EU law conflicts and fantasy.
Yes, my lord. So there's 2 points I made just quickly on Section 9. One is, does Section 9 even apply for you to examine the question of whether there's an arbitration agreement or not? That's a common question between two appeals. And if it does apply, if you can review whatever the tribunal may have said, or in this case didn't say, is there an arbitration agreement here? We, Spain, say that there isn't because of the privacy rule. And I've deliberately left the Section 9 more detailed argument about whether you get past step 1 to Zimbabwe for time's sake. And if there were no further questions, I know Mr. Green is anxious to address you.
Yes, Mr. Green.
I'm very excited. May it please, your lordships. Could I just, before I actually sort of start properly, could I just pick up one point? I didn't want to interrupt my learned friend, but it was a question from my Lord Justice Newey about the effect of the declaration. which we find in, if you can just go to it's volume 7, tab 111. It's just a point of clarification and correction. It's on the EU point, which we'll get to later, but I hope you'll forgive me for just clarifying now. What the declaration on the 15th of January 2019 that we have in tab 111 is addressing is bilateral investment treaties. I think my Lordship may have seen that over the page in the next tab, we have the one the next day, 16th of January, where they clarify on page 3735 by the top hole punch, and you'll see just above the top hole punch the words Charter Treaty on the left-hand margin, and the sentence begins, a number of international arbitration tribunals post the Act of Judgment have concluded that the ECT contains investor-state arbitration clause applicable between EU member states. This interpretation is currently contested before a national court. Against this background, member states underline the importance of allowing for due process, etc. So just to clarify the chronology, post-Act Mayor, this declaration did not say the ECT does not apply. Just taking it in stages.
Yeah, hang on a moment. Wait.
So then obviously the court then moves on in the Comstroy case, and I don't know whether or not the court might possibly be looking ahead overnight. But if the court were minded to have a glance at anything in particular, there are 2 articles by Professor Sarl and Dashwood in volume 8 at tabs 145 and 147. And if I could just ask the court to look at one paragraph of the second article, which is at 147, which is written in characteristically charming and self-deprecating style. The amusing detail is that the first article came out on the very day that Comstroy came out, and Sir Alan remarked that's the first time he's published an article which was wrong on the day of publication, because he'd anticipated that the court couldn't possibly reach the conclusion they reached in Comstroy. And in tab 147 on page 4395, which is the first page of the article itself, if the court looks at the bottom paragraph on 4395, readers may be aware that the author of this comment published a piece entitled Article 26 ECT, the case against an expansive reading of Act Mayor. So that's the article at tab 145. In the August 2021 issue of the European Law Review, which appeared almost simultaneously with the publication of the Comstroy judgment. And if you see there, he says the unhappy coincidence of publication was due to a misplaced confidence that the court would never decide a matter at once so controversial and so commercially significant as the intra-EU applicability of Article 26 ECT, effectively by obiter dictum. And that's the point my Lord Justice Newey was adverting to, that Comstroy wasn't even an intra-EU case. So there was, just parenthetically, deal with this tomorrow, there was no investor party making submissions from the position of the affected parties by the Comstroy decision before the court, and the court invited state parties to come. And the case then is the first case where it's decided, and the peculiarity of the CJEU's procedures is that it's only in that first case that the court, the CJEU, can declare that one of its decisions does not have ex tunc effect. So you get this bizarre, the judgment is bizarre because it's obiter, but massively important. B, the decision on whether it should have ex tunc effect or not, there was no one there to ask for it. There was no intra-EU affected investor before the court in Comstroy. So the court, by surprising everyone, including Professor Dashwood, but many others, effectively disabled itself, as we see in the PL case, from deciding that this should only have this position, which is a massive change of position. I mean, let's make no bones about it, is a tectonic change of position as a matter of international law, and I will show the court tomorrow as a matter of EU law. But it disabled itself from saying this will only have prospective effect. So it is, on any view, absolutely extraordinary.
Mr. Appellant says, so what? That's what they've done.
And I, court may anticipate, I wholly embrace that position for reasons which may be obvious already and will become more obvious when we go to it. But the only other thing I was going to invite the court to do is there is an authority in bundle 9 at tab 162. You just turn to it just to see what it is. Before the learned judge, Mr. Justice Fraser, as he then was, we had a lot of these ICSID awards. It's tab 162, which is right at the back, almost, it's the penultimate authority. We had a huge number of these ICSID awards, which all sing with one voice. I think there's one outlier out of 40 or 50 we identified. This one, I mean, there are lots, but this is the Cavalum decision. Members of the tribunal, Lord Collins, David Hay, and Sir Daniel Bethlehem. They're arbitrators who are not unfamiliar with the law of this jurisdiction, EU law or international law. And the relevant passages, Acmea begins on 4796, page 4796, and a little heading G. And there's the discussion at paragraphs 354 and 355 on 4804, which is the different positions the CJEU has taken on external courts, that the patent one in opinion 1 of 09, and then the different positions they took in.
So which paragraph's that?
Sorry, 354 is the patent one. Opinion 109, 355 is opinion 213, and then if we go over the...
One's Acmea and one's Comstroy, is that
Oh,
right?
no, my lord, they're totally separate, actually. One's a patent convention and the other one, I think, is CETA. But they're just, it's really just dealing with the principles. We'll come to Acmea, and that's just on the court's approach to the impact, the permissibility of having effective international law that's not decided by the CJEU, and the answer is you can have it by international agreement, which makes the Comstroy decision and Acmea all the more surprising. And then the tribunal from 357 onwards, at 4805, in those few short pages that then follow to the end, it's about 4 or 5, it's 6 pages or something, basically do the exercise of considering the interrelationship between the TFEU and international law in a very clear and simple way, and reach a conclusion consistent with what I will be inviting the court to conclude. My lords, I confess that the court's already seen I'm rather keen on a map, because I handed one up of the bundles. What I did last night, and I apologise if the lateness of the hour means there's 1 or 2 page errors, is I sketched out the references that I thought, on the basis of what had happened that far, I would be likely to want to take the court to, just so the court doesn't need to necessarily note down, has a ready record of where things are. Could I just hand those up?
Yeah, of course.
If I may. Thank you very much. and I'll give them to everyone else as well. And then there's these ones as well. There we go. I hope you're enough.
Okay.
Sure. And so those are maybe quite helpful references just on what some of the key things are on the various points. But before I actually dive into the arguments, can I just tell the court what we say the answer is? We say there's obvious jurisdiction under Section 9 of the SIA. If that were the sole basis the court had to decide the point on, and the ECT argument doesn't work for reasons that I'll come to. We also say that the Section 2 and pure 1966 Act arguments matter because if there is a freestanding basis, then the ECT EU arguments don't arise at all. So it's only the Section 9 ground on which the EU law impact is arguably relevant. And for reasons that I'll develop, hopefully relatively simply, if I may, we say that actually the Section 2 argument and the just straightforward 1966 Act argument are dispositive in any event, either one or both. We'll come to that. So that's what we say the answers are. In terms of approach, we would simply submit that actually the questions, for the most part, and there are some quite difficult wrinkles here and there, but for the most part, the questions are relatively straightforward. They involve the interpretation of perfectly straightforward words in perfectly straightforward treaties. They don't call for supplemental means of interpretation on our primary case at all. And the domestic legislation itself is readily reconciled by perfectly straightforward normal principles of construction the court's completely familiar with. So we with respect to the ingenuity and elaborate submissions of my own friend, we respectfully invite the court to find it's a slightly simpler answer. And I'll explain to the court why. In our skeleton argument, we said there's sort of three pillars to the analysis, just in terms of the effect of the primary question, leaving aside the EU point. And the three pillars really are, first, to understand sensibly and properly what the state of the law on sovereign immunity was prior to the SIA in 1966. And the short point on that is that sovereign states were perfectly able to make treaties by which they agreed that other states or even another body, another court, might have jurisdiction to determine disputes involving those sovereign states. Against me, it said that's not possible, and we respectfully say that's demonstrably wrong. So that's the first point, and I'll show the court why we say that. I will also invite the court to consider whether actually the ICSID Convention was just a submission to the jurisdiction, or whether it might be relevant to consider the word conferral of jurisdiction. And I'll explain to the court why that is in relatively short order. But either way, it doesn't matter. This country has an international obligation which is plain on the face of Article 54, and that obligation is clear. So the second pillar So one's got the pre-1966 Act as the first pillar. What was the law on state sovereign immunity? The second pillar is what happens when the ICSID Convention is agreed and is implemented in domestic law. And of course, just parenthetically, the implementation in domestic law immediately throws up the obvious distinction between that and the Pinochet case. Because there's a domestic statute for the ICSID Convention making very clear what the court has to do, and that was not the case in Pinochet.
What, that it wasn't a domestic statute?
There wasn't a domestic statute. So the reasoning was from international law to get back to this jurisdiction. It's a little bit different where Parliament itself has legislated to give effect to the convention. So it's quite important. So a proper understanding of exactly what happens there. It's relatively straightforward. And then the third pillar is to understand sensibly how the SIA, which comes later, works with, we would respectfully suggest, the 1966 Act. And insofar as the Hansard extract we learned a friend took the court to helps, it shows that it was very clear that nothing done by the SIA was designed to stop the 66 Act having effect or convention obligations being frustrated. Indeed, the idea was to ensure that that was respected and nothing said in Section 9 could be read as interfering with the 1966 Act. But we respectfully say it's a very straightforward and totally conventional approach to statutory construction to look at two acts, the second of which was obviously not meant to repeal the first, and construe the two harmoniously. And my learned friend, Mr. Harris, has very elegantly set out a little facet of that argument on the doctrine against implied repeal in his skeleton argument. But the thing when you get to Benyon, you get the same point three different ways, often. It's a common point of statutory construction. If the court's not trying to repeal the previous statute, you construe them harmoniously. It seems to be total common sense, but maybe I'm not seeing the difficulty.
Well, the obvious point that the SIA contains a provision, doesn't it, that actually talks about which statutes are repealed or amended.
Yes.
It doesn't include
Precisely.
It's just
Yeah.
exact.
I mean, anyway, it seems relatively straightforward. But
Yeah.
so could I, with that brief introduction on this bit before we get to the EU
Yeah.
point,
Well, that's later.
could exactly. So on the ICSID immunity one, if I just tell, if I take the court's probably seen actually. I don't know whether I even need to go to the authorities, but seen in our skeleton argument, we've set out at 404. Sorry, so paragraph 29, which was numbered 404 in the bundle, I think in the little bound one it's in, my lord, it's in the little bound skeleton which hopefully reached the court.
Yeah, the 29.
Yeah, paragraph 29. Just in case, did that reach the Chancellor?
I haven't got that. No.
I did send 3 over, I'm sorry. Because it's just, often it's really annoying to have to look at the skeleton at the back of the
That is
bundle and
very
then,
kind. It would be very nice to have something like
well,
that. But
can we get?
it may have
a spare
reached,
one?
maybe something that's got to my clerk, but hasn't got to me.
We
Is that
may have a
not
spare one, we'll just convene. Yeah. I'll get one for tomorrow.
Don't worry.
Anyway, it's,
My lord's got it.
I have one skills reference, but not the reference if he wants that.
no,
Don't worry, Mr. Green. We'll manage.
I-
We'll manage.
we'll sort it out. Anyway,
Okay, paragraph 29.
paragraph 21 is the point, and it's the par in parem argument. A lot of the cases that that we've been looking at look at sovereign immunity, Sultan of Johor, and so tough development and so forth. And the short point is that states were perfectly able to agree between themselves by treaty prior to 1966 that they might submit to the jurisdiction of another state for certain purposes, or even jointly create a court to which they would submit to the jurisdiction of, notwithstanding that they're sovereigns.
Yeah.
And the classic statement of the true basis of the doctrine of sovereign immunity is the statement of par in parem by Lord Wilberforce in E Congresso, which of course has been picked up in Bencar-Bush and so forth in the other cases. So there's absolutely no doubt about the foundational principle of sovereign immunity, but that is of course subject to the exercise of that sovereign immunity, a quintessential example of which is making treaty powers, which is one of the arguments we had in the Gina Miller case, that the government said it was a sovereign power that they could use and so forth. And so from that springs the fact that that there can be no argument that the 1966 Act and ICSID together were ineffective on that basis to amount to a submission to the jurisdiction of contracting states, each to the other, in the way that my Lord Justice Phillips put to Malone and Friend. Because everyone's agreeing under Article 54, they will all enforce awards against each other. So there's absolutely no foundation whatsoever in the law of sovereign immunity prior to the 1966 Act that would stop that from being the correct analysis. And Miles, there's a sort of amusing footnote, if I can mention it, which I do want to take you to. There is the passage in Schroyer in Bundle 8, 146. And it's at 4312, I think. Yeah, here we are. And this is the introduction, so I should just tell the court where we are navigationally. If you look at 4310, this is the Article 54 section of Schroyer. So 4310 is Article 54. And we're now on 4312, and this is the page reference that I've given in number 8 on the list of references for ICSID.
Yep.
So number 8 is tab 146. The whole thing begins at 4283. But then in the notes section to the right, I've said it's about Article 54, and I've put the relevant page references just so the court sees how the document works, 4312 to 4313. And the point about that was that Schroyer makes clear, he talks about the paragraph 3, the enforcement provision, being a distinctive feature of the ICSID Convention. And we'll come to the effect of Article 54. And then rather wonderfully, particularly in the context of Comstrong and the EU point, which we now wrestle with, on page 4313, bottom paragraph, the basic idea of an automatic recognition of ICSID awards is modelled on Article 192 of the Treaty of Rome. So In fact, the final version of Article 54 still bears a strong resemblance to the text of Article 192. Article 299 of the TFEU is almost identical to the wording. So that's also a point I think is picked up again at 4353 as well from memory, which is the second little reference in item number 8. You can see under the heading G, it's basically the same point. And Miles, this does actually feed right back into the argument I was making about the nature of sovereign immunity. So we've got to think what was happening in the world in 1966. So what we know had happened is the Treaty of Rome had been agreed between a handful of member states, conferring on a court the ability, the right to make decisions about the sovereign rights of matters falling in within the treaty competencies of the court in the EEC treaties. So that had happened in 1957 already. And Costa and ENEL, which is the case I've identified at number 7, which is in, we don't need to go to it, but I put the relevant page number there. Costa and ENEL is the case which establishes that, in which the court looks at the nature and quality of the conferral of competence by the members. I mean, none of this is controversial. The court's been practicing in the area of EU law ever since we've been members, but conferral of competence by the member states on the institutions of the EU, one of which was submission to the jurisdiction of the CJEU for the purposes delineated as falling within its competence by the treaties. And later on we'll come to Article 351, which is one of those border provisions saying what is in and what is out, which was the issue in Mika. So the conferral of competence was the effect of the EEC treaties by which sovereign nations submitted to the jurisdiction of a court, namely the CJEU as it now is. And there's absolutely no bar to that happening. And indeed, the fact that that was then modelled on, that was then taken as the model for Article 54, one of the provisions of the treaty, we respectfully say is telling. And that is the strength we would respectfully invite the court to find of the conferral of the agreed conferral of jurisdiction, not on other courts, some other court, but on ICSID tribunals to make the determinations that they make, and on other countries, other contracting states, to enforce those against sovereign nations in their own jurisdictions. And we'll come to the words of the ICSID Convention because they're pretty telling. And that's a complete answer, we respectfully say. But I'd actually go...
Sorry, complete answer to what?
A complete answer to the suggestion that was part of Malone and Friends' case that the SIA, prior to 1978, wouldn't actually allow this to happen, which was his submission before Mr. Justice Fraser, and I think I'm not sure whether it's still part of his case or not. I just want to make it very, very clear.
Sorry, Patrick said the SIA. I think you mean English law, common law, private license.
Yeah, so the Spain's case, as I understand it, is a straightforward case in the sense that they say the common law would not have allowed a waiver of sovereign immunity by the ICSID Convention and as implemented by the 1966 Act prior to the SIA. That's an important limb of their argument. And we respectfully say, well, this is obviously wrong. It was a treaty. The law of state immunity at the time shows why a treaty was necessary. So the states needed to agree, parem parem, as between each other.
The fact that that Article 54 was modelled on Article 192 of the Treaty of Rome rather blows that point out of the water.
Well, it does, yeah. Because they were taking an emblematic example of a conferral of jurisdiction on what's now the CJEU and modelling Article 54 on those words and reaching parem parem, states between each other, not a state with a lady that the Sultan meets in England, private agreement. Parem parem, they're agreeing with each other. And that's why in the private law cases, all the old cases say you have to submit in the face of the court, because it was agreement between me and the state and an individual. And the state not consented to the country. So of course you have to come along and say, I consent. But that's got nothing to say at all about states being able to make treaties between each other. It doesn't tell you anything. It's complete red herring.
Isn't that what Lord Wilberforce says in the Congress of Bill?
Yeah, well, exactly. That's the whole point of parem parem, is what he says in, and it's effectively followed in Benkovic. I mean, he's not dealing in Congresso, he's not dealing with that specifically, but that's the foundational principle of sovereign immunity. And so states can agree between themselves, of course they can, to qualify their immunity, or indeed to confer decision-making power over disputes that involve them on third parties such as ICSID tribunals, and to agree with the other contracting states in a straightforward manner that they'll all run to an agreement to enforce the awards. And that's what they did. So we respectfully don't see that the common law on sovereign immunity on which Spain relies is any impediment at all. And the irony of using the EU model as the basis for Article 54 is fairly heavy in this case, in the light of how things have developed. So that's the short point on that. And then if I may, I haven't been into all of Sultan of Johor, but I don't think we really need to go there. Then we go to item 9, which is the ICSID Convention, which the court can see is most easily found, as my Lord the Chancellor said, in bundle 1 behind the Act. Probably the easiest place to look at it.
We'll do that at 2 o'clock.
I'm sorry, I haven't noticed the time. I was enjoying it so much.
Enjoying yourself so much.
I apologise.
2 o'clock. Thank you.
All rise in favour.